All right, welcome everyone to the Cancer Legal Resource Center's Professional Panel Business Hour. We have a really exciting presentation for you today. We're joined by Mark Gilfix. I'll get a chance to introduce him in just a second, and you'll get to hear from him shortly. But first, I wanted to take just a few moments as folks are joining to make sure that we're all on the same page about the Cancer Legal Resource Center and the wonderful opportunities we have. So next slide. So what is the CLRC? Well, the CLRC stands for the Cancer Legal Resource Center. We are a program of the 501c3 nonprofit Disability Rights Legal Center. The CLRC provides information and resources to people affected by cancer, including patients, survivors, caregivers, and healthcare professionals. Our resources are free regardless of income. And on your screen, you see DRLC, CLRC, but I'm Shelley Rosenfeld. I am a lawyer. I am director of the Cancer Legal Resource Center. So I'm thrilled that you are here with us. Next slide. One really great aspect of what the Cancer Legal Resource Center does is we hold webinars that are free. They are open to everyone and cover a variety of topics. We actually have a Know Your Rights webinar series. Next slide. And it's perfect timing because we have a webinar tomorrow as part of the series. And it is workplace rights and accommodations. You can access all of our webinars after they are airing on our YouTube site, which you can go directly through the CLRC's website to get there. So hope you'll join us tomorrow at noon Pacific. Next slide. And one really wonderful aspect of what the CLRC does, we have something called a professional panel. This is lawyers nationwide who volunteer with us. Mark is on our professional panel. And we wanted to thank everyone who has joined us today, especially our professional panel members and prospective professional panel members. It's free to apply. And basically, when someone contacts the CLRC, if they need help with an area of law in which you practice and in the state in which you practice, we may refer them to you. And all you agree to do is speak with them for half an hour. Anything beyond that is with you and that person who has called the CLRC. And it's a really great way to give back and a minimal commitment. So I hope you apply if you haven't, and definitely keep your information updated if you have, and encourage those attorneys that you know to apply. It's a variety of topics, everything from estate planning, medical malpractice, any type of insurance related matter. And if basically you practice an area of law, most likely it is an area of law that someone affected by cancer will be calling us about. So definitely check it out if you haven't already. Now I'm thrilled to introduce our featured speaker, Mark Gilfix. You see him on our screen. He works for Gilfix La Poll Associates, LLP. He is an estate planning attorney. He'll be speaking today about some really important issues. He practices estate planning, elder law, special needs planning. His background is really special among attorneys. He's originally from Palo Alto, graduated from Stanford with a degree in management science and engineering, and then later attended Loyola Law School's evening program, working full-time while obtaining a law degree, which is extraordinary. He was chosen as his class commencement speaker, so basically you can already tell that he'll be a great speaker today. Graduated near the top of his class, and prior to practicing law, he was a management consultant at the Monitor Group, participating in leading numerous strategy engagements with Fortune 500 corporations. He also enjoyed a career as a professional actor and writer. You might recognize him from several network TV shows, including CSI New York, 90210, The Young and the Restless, and in numerous independent films, national commercials. So he brings a wealth of experience and is a really sought after speaker in the field. His webinars and his firm's webinars reach tens of thousands of people. So This is someone that has impacted so many. We are thrilled and honored that he's speaking with us today. So again, we are honored to introduce Mark Gilfix. I'm going to turn my camera and microphone off because I want everyone to watch, only you. But again, we are honored. So thank you again for joining us and addressing us today. There are lawyers and non-lawyers in attendance. So take it away, Mark.
Well, thank you so much. I really appreciate the very kind introduction, and thank you for having me and taking part in this talk and getting involved with the Cancer Legal Resource Center is something that's very meaningful and impactful to me. And this is something that I'm passionate about, helping families through really tough situations. That's really what we do. Our firm, in again, Gilfix and La Poll Associates, we help people throughout California. I've worked with hundreds and hundreds of families on estate plans. And I don't think you need me to tell you this, but cancer affects virtually every family in America. I mean, the statistics are sobering, and a diagnosis of cancer is overwhelming, and it is terrifying, and it is tough. And it makes estate planning even more important. And I know it's hard to think about that when families are going through really tough times. They don't always want to have to then think about legal and financial planning, but ironically, it's a time that you have to think about it in those moments. And as I said, it's very personal to me. And I want to jump in and really quickly. So again, I want to thank Shelley and the Cancer Legal Resource Center for having me. Just to give you an idea of my personal story and why this is so meaningful, I very rarely have shared this publicly, but I think it's really on point for today. So I want to tell you a very brief version of my recent story. So this is a photo of me surfing, 40 years old. It was like a 40th birthday gift to myself. I went to Fiji, I got scuba certified, and I love surfing, and this was one of the bigger waves I've ever surfed. And it was a time where I felt super healthy. Everything was great. I was vibrant. I was pretty successful in life, and went on this trip. I was surfing, I was active, felt totally healthy. But there was this bump on my leg. Here's a photo of it. I had it checked a year before by my doctor, and he assured me, "Oh, don't worry about it, Mark. Like, we'll keep an eye on it. But if it gets bigger, if it doesn't go, if it gets worse, let us know." So I came back, and they checked it again, and my doctor was like, still not worried about it. He's like, "Let's do some tests just to make sure everything's okay." And then a few weeks later, after the test, I think it was like 2 weeks later, April 8th, 2019 was a day that I will never forget because I got a phone call that would change everything. And that was a phone call where I was told that that bump on my leg that I was told multiple times was nothing to worry about was in fact a malignant tumor, a sarcoma. And that was, and I remember when I was told it was malignant, I didn't even know what he meant. So I asked, "What's the prognosis?" Thinking he'd say, "Oh, surgery, you'll be out a few months, maybe you'll recover quickly." No, he went straight to my survival rate, my survival likelihood. And he said, "Oh, it's better than 50-50. So again, I was expecting like surgery, recovery, and he went straight to my 50-50 chance of surviving. What? And that started the toughest few weeks of my life because I was facing this life and death diagnosis. My mind was reeling, thinking that I was gonna die. I thought I was gone. I thought I was absolutely gone. But then we have some scans. That's me in a sort of stunned state. It was one of the early scans, which showed that happily it hadn't spread anywhere. It was just in my leg. And then I had surgery on my leg. And there's a photo right after the surgery of, they opened it up. And I was very lucky that it was right on the surface. So it was not too intense a surgery. But it was, again, the hardest time of my life. And I had to navigate all this. And to make a long story very short, I thought I was going to die for a while. I thought I was going to have to do chemo and a bunch of other things. And happily, it turned out that the initial diagnosis was wrong, that it was not as serious. It was still a sarcoma, but it was not as serious a sarcoma as they originally thought. There's a bunch of different types. There's a bunch of different grades. Without getting the details, it turned out mine, thankfully, after a misdiagnosis up front, was absolutely dangerous, but was a low-grade tumor that was actually very treatable. And if they had told me that up front and had the accurate odds, I probably wouldn't have been that scared. They would have said something like 90% or 95% you're going to be okay. But the bottom line, it was an incredibly tough recovery. It was an incredibly tough time emotionally, and I had to face my own mortality. And I've worked with hundreds of clients and families, and many of them face cancer diagnoses. And I've helped them through that on the legal planning side, but this was so personal to me. Then happily, winter of 2019, just a few months later, I was recovered. I was physically back. I was mentally back. That's a photo from me on a road trip that I took kind of celebrating my health. I went up down the coast of California because I live up in the Bay Area. I was going down to see some friends in LA. And on that trip, I reconnected with the girl that I was single at the time. I was feeling good again. And I reconnected with this girl that had been on my mind for a while, who I had pursued years before. And I was going down to LA. She lived in LA. So I reached out a couple times. She finally responded, and that this girl named Vera. And here's a photo. The photo on the left is actually when we first went on like a date, or maybe it was like the day later, something, a couple days later. That's a photo when we first really connected. And then the photo on the right is a trip that we took together to Hawaii right before the COVID lockdown. So everything is great. I'm healthy. I meet this girl, everything. And when COVID happened, we bonded, we got closer. Everything seemed great. And then she got a phone call. You see, Vera had found a bump in her breast. And just to be safe, because I had shared my story with her, my journey. So she was like, I should get this checked. And she got it checked. I was like, no, it's almost certainly nothing. You're young. It's just lots of things can cause bumps. And she had breast cancer. She got a phone call that she had breast cancer. So right after I had been through my own journey, Vera, I get a little emotional thinking about this. Vera had to go on hers. And thankfully, I think in some ways, it was meant to be that we were reconnecting, because I was able to use what I had learned and what I'd been through to help her through her journey. She had surgery, had to go through some chemo, something that I didn't have to do. But she was a rock star through it. We galvanized all of our resources to support each other and to support her. She had great medical care at Cedars-Sinai, and she recovered. And I'm happy to say that just about a year after all of that, in the same spot where we went to Hawaii in that trip in February, I proposed to her, and we are now married and healthy. Both of us should be healthy going forward. So the bottom line is, not only have I been through this for clients, I've been through it for myself, I've been through this for my wife, and I hope I never have to go through it for anybody else in my life in the future, but I know realistically it's probably going to happen again. And one thing that I want to just emphasize here in sharing the story is that it's so overwhelming, whether you're a lawyer advising people or someone going through it. You have to control what you can control. There's so much out of your control. But you have to control what you can control. And that's what this talk is really about. So I want to give you, as professionals or members of the community, the steps that you really need to take from a legal planning standpoint if you ever face anything, or if you've already faced it, you know what this is. If you face anything like what my wife and I had to go through. So it's personal to me. So I would kind of say this is sort of estate planning 101, because when you face this, you just need to make sure that core estate plan is in place, that you have it, that it's up to date. So I'm going to go through the 3 critical documents that you and your family need after a diagnosis. I'm going to talk just briefly about some next level planning issues or tools that you should at least discuss or bring up, because anytime you're revisiting an estate plan or creating one, there's no reason not to dive all the way in. If you're going to do it, why not do it right and be aware of some of the tools available to protect your family? We're talking about how you put a plan into place, the most efficient way to do it, and really everything that goes into that. So I already told you my story. I want to just to illustrate the challenges that can happen if you don't have an estate plan. I'm going to tell one more story right now. This is the story of Charles. Now, this is not an actual photo, and Charles is not his actual name, but this is an older gentleman who is in his early 80s who met with me a few years ago. And he met with me because one of his neighbors was concerned about him. He had a house that was kind of falling apart. She visited him. She saw his house was full of clutter, and he was like a hoarder, and he was clearly not really super healthy and not making good decisions. So she kind of got him to call us. She helped facilitate it, but she was not going to be named in his plan or anything. She just wanted to help. And I had a meeting with Charles, and he had no estate plan. He had no kids. He had no family. And he had a lot of assets. He had a house. He had a few $1 million in the bank. He was a pharmaceutical sales executive back when he was working. And we had a solid meeting to put an estate plan in place. He was going to name, he actually was going to name a different neighbor, but he was going to name a professional. I can't remember exactly. He was going to name some people he trusted to step in to help manage his financial and health and legal affairs if he couldn't do it. So we had actually a pretty good plan. We were ready to go. We had some follow-up decisions to make. So I reached back out to Charles a couple weeks later to say, hey, Charles, I want to make sure you reconfirmed your plans, where are you at? He had no recollection of having met with me before. He didn't remember anything about the meeting. He denied having met with me. The bottom line is Charles had lost his ability to remember what was going on. He was basically incapacitated. He had dementia and it was getting worse and worse. We never were able to get his estate plan into place. And so what happened? The county had to come in, Adult Protective Services had to come in, they got a conservatorship, they had to go to court to get a court order, and the county basically had to take over, county workers had to take over his life. People he didn't know, people he didn't necessarily trust, from departments that are overwhelmed and overworked. And most importantly, his stuff got stuck in the courts. No one was empowered to help him who he knew. So he was not able to get an estate plan into place, and it just caused a nightmare. And I bring that up because if you don't have an estate plan, or if someone's going through a really tough medical time, if you don't have an estate plan in place, the family, the loved ones are going to have to end up in court to get the ability to help. And that can be a nightmare, it can be expensive, it can take forever. And it's very public, by the way. So that's what I want to help everybody avoid. You don't want to be in Charles's position. And just quickly, Shelley gave a wonderful introduction, but I think it is relevant that our firm, I'm a partner at Gilfix La Poll Associates. We're based in Palo Alto, California, but we serve clients from San Diego to Wairika. I have a lot of clients in Los Angeles. So no matter where you are in California, we can help. We've been around 40 years. We're celebrating our 40th anniversary. We are a family-oriented firm. My father, Michael Gilfix, my mother, Myra Gerson Gilfix, were two of the founders, but it's not just us. And we've been featured in the national media, but we write books about this. You know, we think about long-term care. We write articles about this. We've been featured in the media a lot. The point being, though, that we think about this and we want to educate people about this whenever we can. So on that note, enough about me. Why do you need an estate plan? Well, again, I think there's a lot of confusion about you need a big estate to need an estate plan. Everybody over the age of 18 needs an estate plan. And when you face a diagnosis, or someone you love faces a diagnosis, that need is heightened even more. Because really, at the end of the day, it's about ensuring that you're covered in a crisis and ensuring that your affairs are kept out of the courts, out of the public eye, so you can avoid the thousands of dollars in the months in delays in getting help to oversee your affairs if you can't do it. It's really, and it's also, of course, about ensuring that your hard-earned assets go to the people that you love without being stuck in the California or whatever state you're in courts for 1, 2, 3 years and ridiculous fees. So estate planning is really about taking control and empowering people that you love and trust. And you never know when a crisis could hit, right? So you could be 25 years old, or you could be 40 years old as I was, and get that phone call of a cancer diagnosis. But we have many clients at all ages where there's an accident or early onset Alzheimer's or a serious illness. It can happen anytime to anyone. And again, the key is, if you don't have a plan in place, your family's going to be stuck in court. And the first step I would say, if anyone here talks to families going through this, or is someone who's ever been through this, you want to talk to your family about this first, to like lay out, okay, who can help me? You want to know who in your family or who in your friend circle might be able to step up and help you if you need it. And then, of course, you need to talk to an attorney. If you're an attorney helping people through this, well, I'll go through what those steps are. But really, and if you need to refer someone, they should work with an estate planning specialist. It should not be someone who dabbles in estate planning, because when you have a cancer diagnosis, the possibility that you're going to need someone to step in the near term is very high. You do not want to rely on documents that may have errors or may not be valid or may not include all the powers you might need depending on your situation. So what are the 3 big documents that really everybody needs? Well, one is a revocable living trust. I'll talk about why a trust is so much more important, better than just a simple will. That's what most people think, I just need a will, but no, you really should have a revocable living trust. And that's not just about after you're gone, that's about making sure you get help while you're alive. Then a durable power of attorney for finances. I'll go through what that is. And absolutely need an up-to-date advanced healthcare directive to empower people in the medical setting if you can't communicate for yourself. And I just want to flag that while I want to focus on the core of estate plans, if you're gonna address estate planning, you should be aware of other tools as well. There's no reason why, even if you're in a crisis, you shouldn't put a really good plan into place. So I'm just gonna spend a moment on if someone facing this diagnosis has kids, and especially if they have grandkids, other powerful tools that they can include in their plan that they should at least be aware of. That's not part of dealing with the crisis directly, but it's a way of protecting assets for multiple generations. So let's talk about revocable living trusts and what those are, why they're so important. There are different structures. If you're married, especially, there's different alternate structures. I'm not going to spend much time on that. Don't rely on an old trust. Even if someone has an old living trust, if you have a diagnosis, it is so crucial to make sure it's up to date. You might have people named who you no longer trust, or who no longer can serve in the role of trustee or help you. It may not be leaving your assets where you want them to go. And when you're facing a diagnosis, you need to make sure the right people are empowered. So I think I'll spend now, I don't know where I cut off, but I'm going to talk about a trust versus a will, and why, especially if you face a cancer diagnosis, it is crucial you have a living trust if you have any assets at all. And I'll tell you why that's so much better than a simple will. And I hope everybody can hear me. I hope it's always tricky. So a will. This is what people traditionally think of as when I'm going to leave assets to somebody, I'll have a will. And a will is not the best tool for 95% of people. Why? Because if you leave assets via a will to your family, your assets have to be stuck in something called probate. In a court process, it's public, it's time consuming, it's really expensive. Up to 4% of your estate could be lost just in probate fees, and you're subject to the court's calendar. And if you love dealing with the DMV, then you'll love sticking your family with probate, because it is a bureaucratic nightmare and it takes forever. It's the way lawyers make a lot of money. It doesn't help families. And a will is not helpful to you while you're alive. So if you face a cancer diagnosis, you need to make sure people are empowered to help you if you can't manage your own financial or legal affairs. You need to make sure you've empowered somebody. A will does nothing for you while you're alive. You name an executor, the executor can't do anything until they have a death certificate, right? So they cannot help you while you're alive. So a will is not helpful while you're alive. It means your assets are stuck in the courts after you're gone. So a trust, on the other hand, keeps your affairs private. Trust is not a public document. When you pass away, your assets go to people that you love without being stuck in the courts. It still requires some lawyer help, but it's a lot less than if it's a probate. But I think really importantly, when it comes to dealing with illness or a cancer diagnosis, you get to name backup trustees. And they're not just empowered to help oversee things after you're gone, but they can also step in to manage your major financial assets if you're incapacitated, or if you just want to have someone take over management of your major financial affairs right away. If you have a very serious diagnosis and you're going to be a lot of treatment, I have many older clients especially where they say, you know what, I'm going to name my son, who I really trust, or someone else as trustee right away, so they can step in and manage my major financial assets starting from the time I sign this document. So it's a way to empower people you love to help you with your major assets and to keep your assets out of court. So if you face a diagnosis, time to revisit. If you have an older trust, you have to, I strongly recommend someone revisits it with an estate planning attorney, someone who really knows what they're doing. And two, if you don't have one, you need to get one into place as part of this. Let's go to document number 2, a durable power of attorney. And I joke that power of attorney is kind of the lamest sounding superhero ever. I have power of attorney. The terms can be a little confusing, but let's say you're out of it. Let's say you're in an accident, or you have dementia, or you're in very serious cancer treatment and you just can't manage things. What happens to your day-to-day bills? What happens to dealing with the utility company, the cable company, your retirement accounts? Well, that's where a durable power of attorney for finances comes in. It's a document where you can empower people that you love and trust to step in and help with day-to-day financial issues. And there's a couple ways to do it. You can make it where it's springing, meaning you sign it, let's say I name my wife Vera as my decision-making agent there. I can say Vera can only act if I'm incapacitated, meaning she has to have a note or a couple notes from doctors saying Mark can't manage his affairs. Or I can give that power right away and say, you know what, from the time I sign this, Vera, you can sign on my behalf. You can deal with day-to-day financial issues on my behalf. She would give a copy of the power of attorney document to whatever entity or bank or whatever needs to see it to show she has authority, and she could sign on my behalf. So power of attorney kind of works in concert with the trust to make sure the trust handles your major assets, if you have savings, investments, or if you have a property, but the power of attorney governs all other day-to-day financial issues. And if you face a diagnosis, critical to have this up to date. And we always say you don't want, if you have any assets, you have any family, you don't want to check the box form. A lot of people come to me and I'll review their documents. It's literally a check the box form. Those are better than nothing, but they don't cover a lot of critical issues that we think are really important, especially if you face, if you have financial or tax issues, you have a family. We don't think that's great. It should be with a lawyer, but hey, I'd rather someone have a check the box form than nothing. But it's really important that these are updated every 3 to 5 years. If a power of attorney document is older than 5 years, we find that even if it's valid, banks and financial institutions and government agencies, they view them as stale. They don't like them because they don't trust that it's the most recent version. So even if you have a power of attorney where you've named people you trust to step in, if you face a diagnosis, update it. Just do it, and it should be with an attorney. I recently had a call from a friend. His dad had executed a power of attorney. His dad was in the hospital, couldn't make decisions anymore. And his son, who was named in the power of attorney, was going to the bank to try to help get access to dad's funds to pay his medical bills. And the bank saw the power of attorney. They said, that's great, but we need an attorney note verifying that an attorney helped you with this. And he did this on his own. He did it online with his dad. So no attorney could vouch for it. And they said, oh, you don't have an attorney who can vouch for it? Okay, your dad needs to sign a note saying, I understand X, Y, and Z, that I gave my son this power. And this long note that he had to sign. He couldn't sign because he was out of it. So it was this ridiculous cycle that the bank put him in an impossible situation. So he ended up having to go to court. The bottom line is, if you face these issues, you should work with an attorney to create an updated power of attorney document. I know it sounds self-serving. I didn't make this up. My friend told me that Chase Bank refused to deal with him unless they had a lawyer's note or unless his dad could sign something. So the power of attorney is a crucial document. You should name at least 2 backups in it. So that'd be person 1 who would step in right away. And then if they couldn't do it, you should have at least 1 other backup in that document. Same with the trust, by the way, for backup trustees. You don't want to just name 1 person. You should have at least 2 backups in case the person you name can't serve. So we have the trust, we have that power of attorney. That covers your financial life if you face issues or medical needs or a cancer diagnosis. Now, what about the medical side? That is an advanced healthcare directive. So that's the document you name the person or the people who can step in and communicate with doctors, view your medical records if you need that help, if you can't communicate for yourself. And again, when you are facing a diagnosis, so technically advanced healthcare directives are usually only valid if you can't make decisions. But if you have one and you name someone that you love and trust, usually that's something they can use to get more access to your records and help you out. If you're the one going through this, or if you're trying to help a loved one, they should name you, if they're okay with it, they should name you in an advanced healthcare directive so you can get more access to visiting them, to talking to doctors, to viewing medical records, and especially if you can't make decisions for yourself, the person facing the diagnosis. An advanced directive not only names people who are authorized to step in and communicate on someone's behalf, they also can communicate your wishes. So let's say you're in a long-term coma and 2 doctors say you can never come out of it. Well, you may want to let your loved ones know, hey, keep me alive in that case, or no, let me go. It's okay to remove tube feeding so your loved ones don't have to face that very tough decision on their own. So the advanced directive, 1, empowers people you love and trust to step in and communicate on your behalf if you need it in a hospital setting. And 2, it can communicate your wishes for very tough medical decisions. So again, when you face a diagnosis, these are the critical documents: the trust, the power of attorney, the advance directive. And I want to add a 4th element to this, and this isn't really a legal planning tool, but this is something that my mother, Myra Gilfix, has written articles about this, and she served in this role for me when I faced my diagnosis, and I tried to serve in this role for Vera when she went through her cancer journey, and that is a patient advocate. So if you face a diagnosis, or if you're the loved one of someone who faces a diagnosis, maybe it's you or maybe it's someone else, they should have a patient advocate. What is that? That's just someone who goes to meetings with the person facing the diagnosis, someone who asks questions, who takes notes, who, if someone's in the hospital, someone who's there with them and who asks. It can be as simple as asking doctors and nurses to wash their hands whenever they come in, to question, hey, did you take care of updating the medication order, or can you bring some fresh water? I used to think that if you were in the hospital, you just outsource everything. Like, let the staff take care of you. They got you. They are overwhelmed. They are overworked in many cases. And all the meetings you have when you face a diagnosis are so overwhelming as the patient, because you're facing your own mortality, right? Like your head is spinning. It's scary. It's terrifying. It is hard to take notes, to get multiple opinions, to stay organized. And you need second opinions, by the way, if you face this. Having someone, and ideally the same person for all of this, who goes to those meetings, who asks the tough questions for you, who takes those notes, and who's in the hospital with you before or after a surgery or for a long-term stay. It is so crucial. So you should have a patient advocate. And if you can get my mom, Myra Gilfix, as your patient advocate, I strongly recommend it. She was there for me, and it made a massive difference in my care and may have prevented some unnecessary treatment that I didn't need, because she was so good at asking questions and pushing for second opinions that ended up correcting my diagnosis in the right direction. So, okay, trust, power of attorney, advance directive, critical documents should be done by an attorney. If you're an attorney helping someone with this, if you're an estate planner, hey, help your clients with it, not refer them to somebody who can help them with this right away. Now, what are some of the other non-legal steps to take? Well, you should talk to family members. If you're facing the diagnosis, or if it's your loved one facing the diagnosis, talk to them about it. You should communicate about these documents. You can name someone without their permission. You don't need to like talk to someone ahead of time and you can still name them as your trustee, as a backup trustee at least, but you should talk to them, because if they need to step in, then they have the right to turn the role down. So I think communicating with family and with loved ones ahead of time, it's so crucial. And when you face that crisis, hey, that's a logical time to bring the family together and to talk about these crucial issues of who's going to step up, who's going to help me, who's going to be able to help me. And whether you just prepared documents, you should frankly give copies, at least of the power of attorney and advance directive, to your loved ones. But you should talk about it as much as you can. Sunlight is the best disinfectant. Sometimes people are unsure of who to name. Talk to your family, because if they need to step in, it's a big responsibility. So you want to make sure that the people you're naming are aware that they might be named in these documents. So if you face the diagnosis, the trust, power of attorney, advance directive, I want to add I know this presentation is not about next level estate planning, but when you're revisiting this, especially if you have some assets like a home or significant investments, or if you've done well, or if you're just concerned about your kids. Because when I faced my own diagnosis, I started thinking about the future and my family and how to protect everything I worked so hard for. So I just want to lay out an enhanced option. If you are going to create an estate plan, why not add really protective tools? So I'm just going to flag this: family protection trust. So I'd say if you are updating your plan, if you have kids, I do not recommend that most people leave any assets to their kids. Instead, they should create family protection trust for each child. Bernie Sanders does not like these. He's on record for this. It's not a political statement. Now, what is a family protection trust? They're generically known as dynasty trusts. So I think most clients that I work with, I recommend these. You don't have to be ultra high net worth or even high net worth for these to be valuable. So when you're doing this, and I know I'm throwing a lot at you, but if you're going to create an updated estate plan, why not protect your kids? And by leaving your assets to your kids, to trust, family protection trust for them, generically known as dynasty trust, rather than to kids directly, there's three big benefits. One is if you leave assets to your kids, and let's face it, when you face a diagnosis, that becomes very real, that idea that your assets are going to go to people you love. If you leave assets to them and they get married and get commingled, they could lose half of what you left them in a divorce settlement. If you leave it to a trust, the assets stay separate and are protected in a divorce settlement. So again, for your kids, for future generations, if they're ever sued, if you left money directly to them, that's all exposed. And we have so many frivolous lawsuits out there, some very genuine ones. Unfortunately, they're drowned out by a lot of frivolous ones as well. But either way, if your child is sued, if you leave assets to a trust, there's some protection against creditors. Nothing's 100%, but it helps add a layer of protection to make it harder for someone suing them to get access to the money. And really powerfully, estate tax laws are very flexible right now. You can pass $12.92 million per person free of estate taxes, but who knows what the future will bring. Maybe it'll be much more strict in 10, 20, 30 years. If assets are in a trust, when your child passes away, and this is especially big for my clients who already have grandkids, the assets in the trust go to the next generation with untouched by estate taxes. So I can save hundreds of thousands or even millions of dollars. And this is not a tool that should only be for the ultra wealthy. We just think it's something everybody should be aware of. So if you're going to do an estate plan, hey, why not at least be aware of really powerful tools to protect what you work for? And you don't have to have banks or third-party trustees for your kids. Your kids can actually be in charge of these trusts for themselves after you're gone. So, again, if you're going to address estate planning, why not look at tools to protect your kids and your grandkids? And these should not be tools only reserved for the dynastic 0.1% with billions of dollars. Any family, middle class and up in America, can benefit from creating these trusts for their kids. One other issue: if you have a child with a disability, whether you have a diagnosis or not, you do not want to leave assets directly to them if they're on the autism spectrum, if they have mental illness issues, if they have physical disabilities. If you leave money directly to a child who has a disability, well, one, are they able to manage it? Maybe, maybe not. Could they be taken advantage of by nefarious third parties? All big problems, but another big issue is public benefits eligibility. So if you have a child who can't work, it doesn't really matter what reason it is, they qualify for disability benefits like SSI, supplemental security income, Medicaid or Medi-Cal, as we call it in California. If they inherit money directly, they may no longer be eligible for these programs. So they may lose thousands of dollars a year in public benefits. So you do not want to leave assets directly to them. You want to create a special needs trust to leave money to that trust for their benefit. And it doesn't interfere with public benefit eligibility. And you can name a trusted third party to oversee the money for your child with that disability. So just because a diagnosis or an urgent situation means you have to address estate planning right away, that doesn't mean you should just skip over really important steps, because you don't want to just create a plan really quickly just to get it there and neglect to protect future generations. And again, you do not have to be ultra wealthy for these tools to make sense. And they're not that expensive to set up. It varies by law firm, of course, but we've worked with hundreds of families on special needs trusts. And that book that I have displayed here, Special Needs Trust Creation and Management Guide, I co-authored that with my father, Michael Gilfix. It's available on Amazon.com. Just look up Gilfix Special Needs Trust there. And we also give it to our clients as well who have children with disabilities. And check out our Gilfix Law YouTube channel. I'll have a link for that later here, but we have a lot of free webinars about all these issues and a lot about special needs planning. So if you have a child with a disability, crucial that you have a special needs trust in place. So check out our Gilfix Law YouTube channel and see one of our many videos on special needs planning. And our book is available as well. So I threw a lot at you. I mean, I don't want to get caught up in the family protection trust or the special needs trust. Those are really powerful add-ons and they may be necessary. But the key though is revisiting your plan or getting a plan into place when you face a diagnosis. It should be part of that checklist, along with getting second opinions and along with consulting with as many specialists as you can. So what are some of the key decisions that have to be made, and how can we help guide our clients or guide family members through this? So the key decision is really who's going to step in, who's going to manage my day-to-day financial affairs. That's the successor trustee. It's also the person you're naming in the durable power of attorney. It's called your attorney in fact. Very confusing terms, but broadly think of it as who's my financial backup, who's going to step in for me if I become incapacitated, or if treatment's really intense, you just don't want to deal with finances, who am I going to give the power to right away to deal with my financial issues, to manage my business, to pay my bills, to manage my investments. So you need to think about that. And it's not who you love the most. It doesn't have to be a family member. The best choice would be a very trusted, immediate family member. That's not always the right choice though. What if they're not responsible? What if there isn't a good relationship? There are professionals who can serve in this role. You can name very close, longtime friends, although that can be dicey over time. But you can also name professionals or professional fiduciaries who do this. There are bank trust departments. Be careful with those, and some attorneys will serve as well. So you just want to be aware of the options and talk to as many people as you can who you might consider naming to make sure that they're up for it. And if there's no one that you know in your circles who can do it, you might look to the professional world. So the decisions that have to be made, if you face this diagnosis, do you want to give people the power right away to step in and manage your financial affairs? And that would be in your trust. You would say, they're not a backup trustee. I'm actually naming them as my current trustee. You can do that. Same with the power of attorney. You can make it springy, meaning someone only has the power to step in if they're incapacitated and they have a doctor's note verifying that, or you can give it right away. So no doctor's note is needed. You have to be very careful with that. Often we hear of celebrities getting ripped off by their business managers because they gave their business manager power of attorney and didn't really pay close attention, giving them their manager the ability to do whatever they want pretty much with their finances. They're not supposed to be able to do whatever they want, but there are very few checks and balances up front. You can catch them later. So you have to make sure you trust the people you name, of course. Who do you want to name in a medical setting? That's a really crucial decision as well. So very, very important. Now, how do you put these documents into place? Pretty straightforward. It should be a meeting with an attorney who specializes in this. Again, with a diagnosis, the stakes are so high. I just don't think people should touch online planning. I guess an online-based plan is maybe better than nothing. Although we see people making bad decisions, we see people not finishing them, we see people signing them improperly. So it really should be with an attorney. You need some expert guidance to make these decisions, because again, this is not a 5 years from now, 10 years from now, 15 years from now type of thing. If you face a diagnosis, it could be immediate when you need this help. So you need to make sure these documents are ready to go right away. And then when we meet with clients, we have a meeting. sometimes one other meeting, but often one meeting is all we need. We can get a lot of the decisions. Maybe we have follow-up emails to finalize. We send drafts to our clients within 2 to 3 weeks. Once they're approved, they come in, they sign them with a notary. And if it's a really crucial medical situation, we, like other attorneys, can speed it up if we really need to, if it's urgent. And then once it's there, you want to share it with your family. You know, the power of attorney, the advance directive, whoever's named in those documents should get copies of those documents. The trust, you don't need to share everything in your trust. If it says where your assets are going, you don't need to immediately share that. There are ways to share that someone's a trustee without showing them your bequest plan. But it is really, really important to get these done very efficiently with an attorney. Now, how are they used in emergencies? I get this question a lot, like, well, okay, let's say I have these documents into place, but how do they actually, get used? So if you have a living trust, and let's say you need someone to step in. So if you want to just name them, you would voluntarily say, I am no longer the trustee of my trust. I am actively signing a document to say that Vera is the trustee of the Mark Gilfix trust. If someone is incapacitated and you're the next person named in line as trustee, well, you have to get doctor's notes saying, there's some specific language doctors use, they usually know it, that they would sign saying, Mr. Jones is, based on his medical issues, unable to manage his finances and is thus incapacitated, or something like that. You would give a copy of that letter from doctors, or sometimes 2 letters from different doctors, along with a copy of the document to the bank or the financial institution, and that should be enough to give you the ability to step in and manage. But as I pointed out, though, if it's not done by an attorney, sometimes banks won't even accept homemade power of attorney documents. So really important to do with an attorney. So the attorney, if needed, can contact the financial institution and send them validation and verification that it was created with an attorney. So you want to give copies of the power of attorney to as many financial and government institutions as might need it. There's no reason not to. They have a right to ask for it. The trust, you typically give a copy of the certification of trust. Don't worry about the details there. You give copies of documents proving who the trustee is. The advanced healthcare directive for medical decision making. No reason that you wouldn't just give that to your doctor, to your hospital right away as soon as you create it. So really important to share these documents because they only work if you have a copy, right? Just because you name someone in a document, if the bank or the financial institution doesn't know that you're named, they can't do anything. So you want to talk to your family, create the documents with an estate planning expert. It can be done in a matter of days if it's an emergency, but usually it's more like a couple, like 3 to 6 weeks to finalize. And then get copies to the people that need them. And an attorney can help guide you on who needs to get copies and how you can get it to them the right way. And you give copies to banks, to family members, to anybody who might need to see it. And continued communication with family is so crucial. So again, if you face the diagnosis, I know it's another thing on the list, but it's just such an important time. It should be not up there with the immediate emergency meetings with doctors, but I think a referral to talk to an estate planning specialist should be on that list to make sure, because the worst case scenario is your illness puts you out of commission for a while and nobody's empowered to help out. Nobody's empowered to talk to doctors on your behalf. And if God forbid something happens and you lose your battle or something happens, if you don't have an up-to-date estate plan, your assets might not go where you want, or they might not be protected for future generations. So you want to talk to your family. And I think this is really crucial. I give this in every presentation or a version of this, but especially if you face a diagnosis, I think it's very easy to say, I have too much on my plate, I'll get to this later. We need to overcome the danger of delay and denial. I think the denial part is probably not as big a deal if you face a diagnosis, denial that you'll ever need it. Because, if you face it, this stuff is real. But sometimes people feel overwhelmed or they think, I did documents 15 years ago, I'm good. You might not be. Or people say, I don't want to deal with a lawyer. Let's just cut. I hate it's like I say to clients, you can spend a bit on a lawyer now, or your family's going to be spending a lot on lawyers later, and it might be all of your assets exposed later. So it's so powerful to plan ahead. And one of the upsides of a diagnosis is it makes you face your mortality, which can be a really powerful and positive thing too. So you can appreciate what you have and appreciate the people that you love in your life. So it's a chance to bring your family together, not just something that should be scary and full of dread. So please spread the word. I'm almost done here. I know it's been an intense talk, but You can put your phone to this and you can get a link to our YouTube channel. So I invite you to join our growing YouTube community. It's called the Gilfix Law YouTube channel. We have a few hundred subscribers now. We're just getting started. And we plan on putting a lot more totally free educational content out there about, and we'll post this there, but also a lot on the issue of special needs planning and protecting assets for your kids and what to do, other videos about what to do when you face an emergency. I also have an Instagram channel I just launched. It's Instagram/Mark Gilfix. I just started doing it. It's gonna be like 60-second legal and health tips from everything I've learned. So please join me there. I'm just getting started there. I'm gonna have a lot of free content there. I just want to educate and reach as many people as you can. If you're in California, my firm, my team can help. Or if you're an attorney and you don't practice in this area, we're happy to chat with anybody who faces these issues. And as part of the CLRC program, the Cancer Legal Resource Center program, we're happy to chat. If you're finding us through the CLRC and you or a loved one is facing this, happy to chat for 15, 20, 25 minutes, no charge, to just answer questions if you or a loved one faces a cancer diagnosis. Because I really want to give back to this community, because as I've shared, it's something very, very personal to me. And so many people face this and feel so alone and so scared and so exposed. So let's work together to get that legal plan into place to make sure that you're at least covered from a legal perspective. Easy to find us. We're gilfix.com and 650-493-8070. Easy to find us though. So, check out, I would love to stay connected with everybody here. Check out our YouTube channel, the Instagram thing. But either way, I'm a resource. I am part of the CLRC now. And I'm proud to be part of it. So I hope this was all useful. And Shelly, again, thank you so much for having me. And I'm happy to follow with people. If you have notes, you can contact Shelly. She can forward it along. Thank you for giving me the chance to share my experience as well.
Well, thank you so much, Mark. And we, first of all, I think I can certainly speak for myself, but the attendees, that this has been an extraordinary presentation. We do have about 7 minutes to take questions. If we don't have questions coming through, I'll leave sometimes. I suspect that people were really listening very closely and might be submitting questions now. We did have one question initially where someone was asking about the link after. So I will say that, first of all, there will be more than one way that someone can watch this presentation after, which is that it will be through the CLRC YouTube page, and Mark and his firm will also have access to the video after. So if someone missed a part of the presentation or wants to re-listen, the great thing is that someone can then access it after and pause and re-listen. I want to also mention that someone had said that the sound was lost when you started talking about revocable trust. So I initially thought that it was just my audio, so I wasn't entirely sure, but I wasn't sure if there was any part of that, since we do have a few minutes, that you wanted to make sure that was covered. If you want to either move to those slides, maybe you went over it enough, but I just wanted to give you the opportunity that was the part that someone had stated was where the audio was lost.
Yeah, and I just stopped sharing because we've shown so much. So I think, just to reiterate, because I didn't know where it got. I'm so sorry about that. But the living trust, I think the key thing is, for again, 95% of the people I work with, they need a living trust, not a will. A will, we actually prepare a pour-over will as part of that package. But a will does not help you while you're alive. You name an executor, they can't do anything to help you until they have a death certificate, right? And only then they're empowered to deal with all the court issues and probate. So a living trust is so much better, one, because you get to name a successor trustee who can step in and manage your major assets if you're incapacitated, and you can name them right away. You don't have to only say upon my incapacity. I have some older clients or clients facing serious medical issues who will name their eldest child, who they trust, as their trustee right away. So they're saying that the day I sign this, and their trustee has to sign to accept it, they can step in and manage all their major assets right away. And a trust, there's so many ways that you avoid probate. So after you pass away, your assets aren't stuck in the courts, and we can build in, and we talked about family protection trust, special needs trusts. Almost by definition, if someone just has a will, they're not thinking about protecting assets for future generations. They're not thinking about protecting a loved one with a disability, because a will is not really set up for them. Well, instead, if you have a trust, it's usually part of a comprehensive estate plan. So trust is so much better. It costs a little more to set up, but it could save your family. Even if you don't consider yourself wealthy,
can save a family tens or even hundreds of thousands of dollars down the road. So much
And
better.
yeah, I mean, that's fantastic and very helpful. One thing is, I think many folks listening today will be wanting to contact you for advice, or maybe to work on the big three documents that you mentioned. But for someone looking into an estate planning attorney, what are some qualities, in your opinion, that someone should really be able to see? Is it the right fit? How important is that someone does feel comfortable with the estate planning attorney? I wanted to know if you could speak to that a little bit, especially for someone going through a diagnosis, but quite frankly, anyone.
Yeah, that's a great question. So how do you find the right lawyer? So one, it should be a lawyer who specializes in estate planning and elder law probably as well. If it's a lawyer who does business contracts, litigation, medical malpractice, oh, and I can do your estate plan as well, that's not the right person to work with. No offense to generalists, but especially if you face a diagnosis, that's just not what they do. Like, you wouldn't go to me. I have attorneys on my team who can help with malpractice claims. I'm not the one you want to see for a personal injury claim. I have amazing litigators on my team who can, but just like you wouldn't want to see them to set up your estate plan. So I think one, someone who specializes in this, who's done it for more than a couple of years. And two, when you talk to people, someone that you enjoy talking to. I think I've encountered some old school estate planners who are very formal and stiff, and they talk very intensely, and they don't get into anything beyond the very basics of legal. But you want to feel very comfortable. It's, part of what we do is like counseling. It's not just the estate plan. We've been through this before. I've helped so many clients through this situation. I can be helpful beyond just the core documents, because it's all interlinks: your care, your assets, your financial management. So it doesn't have to be me, but like, it should be someone who's very experienced, who specializes in estate planning and elder law, but also someone that you enjoy talking to, someone who you look forward to talking to. I mean, yeah, you have to pay them, so that's a little bit of a pain, but you want to feel like they will answer all your questions without making you feel dumb. You want to feel like you should leave. And this is the same for doctors, by the way. And this is a really important point. When I was going through my cancer journey, and Vera too, I met with multiple doctors. In some meetings, I would walk away feeling like, I got this, I'm good. In other meetings, I would leave them being like, I'm done, I'm gonna die, this is miserable. And they were delivering similar news, by the way. And I think it's similar for lawyers. Some lawyers you talk to, you leave feeling energized, like, I got this. Other lawyers, you leave being like, oh God, this is miserable. So I think in all parts, on the medical side, find doctors who are positive, find doctors who are supportive, because that is healing on its own. I swear to God, that will help your healing process. Get away from negative doctors. Get away from toxic doctors who talk down to you, who don't ask questions, who push back against getting second opinions. So that's a different issue. Get away from them. Same with lawyers. Get away from any lawyer who makes you feel like you can't ask questions. Get away from any lawyer who tells you this is how you have to do it, and that's it. So I think it's really important in the medical and legal side that you feel a connection, that you feel positive from those interactions.
That brings up a good point. Also, someone is a lot more likely to share information about their either medical or legal situation if they're feeling heard and feeling comfortable that the lawyer really cares about their situation.
100%. So many times I'll have a meeting and we'll go through everything, and then like we'll kind of get to the wrapping up part. And this is true, and I think this is why hybrid can work, but remote work is tough, because so much of the time it's like, as you're leaving the meeting, and this can happen on Zoom too, as you're leaving the meeting, you say, oh yeah, by the way, I got this other, like, it'll be a huge new issue that we need to now address. And it's because there's this open line of communication. Like, sometimes I'll have meetings with clients, and at the beginning, I take some time just to get to know them. Once in a while, clients say, no, that's wasting time. I'm paying you for the time, let's get into it. And I'll be like, okay, and I'll gently circle back. And 100% of the time, clients open up and they realize why it's so good for us to get to know you, because it opens the lines of communication and we get to better solutions. And especially, again, when you're facing a diagnosis, you want to feel open lines of communication. You can ask questions. I think that's healing by itself.
Such great points. Thank you so much again, Mark, for sharing your story and also your expertise. The CLRC, we hope to seek CLE credit for this presentation. But no matter what, we are grateful for all of those who attended and are checking this out either in real time or after. This has been an extraordinary opportunity. Thank you again, Mark. We're gonna wrap up, but please do contact Mark's law firm for more information. And of course, if someone has questions for the CLRC about a variety of legal issues, fill out an intake with the CLRC either on the phone or online. So thanks again, Mark. This has been an honor to have you here with us today. We're going to wrap up. So thanks again.
Yes, thank you. Thank you so much again, Shelley. And I'm here as a resource for the CLRC. And I hope everybody staying safe, sane, and healthy, as my mom likes to say. And if you do face a cancer diagnosis, connect with the CLRC. And if I and my team can be part of that, of course, let us know.